Yes, Dr. Bennett.
Good morning, Lords. Three short items of housekeeping. There's three documents on your desk, which with discussion with my learned friend I've put in. Two are extracts from the Council's constitution in place at the time of the relevant meeting in July 2021.
Yes.
Introduction, part 2 introduction, constitution with parts, which I've entered is where my Lord Justice Lewis might have been referring to earlier. And then within the same part 2, you've got section 8, regulatory committees and boards. So those two documents, and I'll explain those if I may when I get to ground 4.
Yes.
The third document rather is a judgment of this court in Gathercole, and that deals with, I'm relying on that for the section 31.2a point and the approach to that, and I'll explain that when I finish off ground 2, if I may.
Yes.
Thank you. So, unless the court has any further questions for me, I propose to carry on with ground 2 and to tie that off and then move to finish my case by noon.
Yes.
Thank you. My Lords, we were in that part of ground 2 just exploring the rationality question, and I do need to correct something that I said yesterday, which is if I could invite the court to date to 284 in the supplementary bundle, please. We're in the figures section again.
Oh, yes.
Just to remind the court, top of the page, you've got 4 applications there for permission. Nicholson Road, Pennyfeathers, Westacre, RST, which is another planning permission. I accepted the proposition that was put to me by my Lord Justice Lewis that there was a 70,000 shortfall if you take out Pennyfeathers. That's not correct, because if you add up RST, Nicholson Road and Westacre, you get 776,043. And of course we know from page 184 that the cost of the works was around 777.
Sorry, you lost me.
Sorry, my Lord. So,
can you just take this more slowly?
Of course.
284.
You've got
Nicholson. Sorry, can you just?
So sorry.
My question.
Yes.
At Nicholson Road, I see a figure starting 301.
Correct.
Right. So let's just use round numbers for ease of arithmetic for now, right? So 301, and then I see Westacre 406. So do we add those two and get to roughly 707?
And RST, my Lord, yes.
Oh, right. So we still have to add RST.
Yes.
But what is RST? It's the first time it's been referred to in this hearing at all.
Well, that is another planning permission which had the same impacts on those junctions, and that's why it's set out in here.
It's kind of you to give evidence, but could you take us, please, to the evidence?
So 283 on the previous page, you'll see the split, Nicholson Road, Pennyfeathers, Westacre, RST, and that's where it says looking at the movement totals. And that shows you the
RST there.
Sorry, middle of the page, RST 140.
Yeah.
Oh, that's underneath what you just said, yes.
Yes.
Looking at the movement totals.
And gives you the total. Sorry, my Lord.
No, what's the point you're making? You were reading, looking at the movement totals.
So looking at the movement totals, the first figure in the calculation below is the number of dwellings associated with the commercial development will be equivalent to, which is then added to the actual number of new homes proposed / permitted to give a total. And then you see the split between those schemes of those movements. So that is in the evidence, my Lord. You then get the total, and that translates over the page. This gives us the following totals and percentage splits. And the point I was just correcting was that I was in error to say that if you took out Pennyfeathers, there would be a £70,000 shortfall, because if you added up the remainder, you'd have 776,043. So I was in error to accept that proposition.
What would be a matter of a few pounds and pence short.
Exactly. Yeah.
It's unfortunate that the woman who did this exercise and made a witness statement has told us nothing about these figures.
Well, my Lord, the witness statement was put in to address a pleaded ground of a failure to have regard to an obviously material consideration. And that obviously material consideration was Pennyfeathers. So, my Lord, I accept that witness statement is not as full as I've explained it, but it was responding to a pleaded ground, which is somewhat narrower in scope than the debate I've been having with the court.
This slightly worries me, Dr. Birds. I don't want to criticise any individual at all, but it worries me at the level of principle, because one of the functions of judicial review proceedings is not simply to meet the pleaded case, but what I've in many judgments described as, it's often inaccurately called the duty of candour. It's actually, the full phrase is the duty of candour and cooperation, because what we have emphasised in many judgments is that public authorities have a duty to assist the court to achieve the right result. And this goes back decades to Huddleston. There's Privy Council and Supreme Court case law on this. And the point is that it's not simply like ordinary litigation where you meet, for example, the pleaded case, but you put all the information before the court which is going to be necessary fairly to deal with the issues. And this was not clear to, it wasn't clear to you, I think it wasn't even clear to you yesterday. So here we are on the second day in the Court of Appeal, when for the first time we learn that there isn't a 70,000 shortfall. And as my Lord says, that hasn't been clearly explained to the court by way of evidence. Well, I may be right, and maybe we should proceed on that footing. Yeah. But I have to say that I am disappointed that the Court of Appeal finds itself on that situation on day 2 of an appeal.
Well, I apologise, my Lord, for that. It was my error to accept the proposition there was a £70,000 short. That wasn't put in evidence by my client or said in any witness statement there was a £70,000 shortfall. That was my fault. And I was seeking to correct that inappropriate acceptance of that proposition. So if any blame is to be levelled at that, that's
well, that's very gracious of you, Dr. Bose, and we of course accept that apology.
And I mean it sincerely, my Lord. I didn't for a moment mean to mislead my Lord when I accepted that proposition.
Well, there's still a fundamental problem, because we're a court of law and we can only proceed on evidence.
Yes.
The law is that you're supposed to publish, and you accept you didn't publish the proposed or final agreement. You appear to be inviting us to say there's no material prejudice, applying some edgy, because the figures are the same. We haven't a clue whether they're the same. The witness statement doesn't explain it. This is an inexplicable, non-self-explicable email dated the 11th of February 2022, sometime before the agreement, saying what likely contributions are going to be. Even if there's no 77,000 shortfall, how can we be sure what's in the agreement, how it was calculated, and that there wouldn't be something to say about it? If you want us to say that there's no prejudice, where's the evidence?
My Lord, I can't improve on the witness statements before the court and this document.
And this document?
Yes.
Is there any explanation in any of the witness statements as to what this email is?
Can I just check that, my Lord, for a moment? My Lord, I think it's not before you, it was before the court below. There was a witness statement from the developer's highways consultant that exhibited that document, and para 12 of Miss Wilkinson's witness statement, which is before you, is referring to, when she's talking about the per unit cost and how they've been calculated and the percentage contributions from each, is referring to that calculation.
And I know that because...
Well, you don't have the witness statement from the... But it was before the trial judge, but it's not before you, so that... I'm sorry, that's...
Whose statement was it?
I'd have to check his name, I'm sorry.
What
I beg your pardon, it's a planner.
Right.
I'm sorry. David Long was started, thank you, at page 458 of the bundle below, in the supplementary bundle below, in the trial judge had, and that's how my understanding is this document came into evidence.
Right. Well, we haven't seen that. All I've got is paragraph 12,
yes,
which doesn't refer to it to page 44, and that's the evidence I'm going on, and I've got the email. and I can only work with the evidence that this court is provided with.
Yes. Well, I accept that, my lord. It was before the trial judge. There wasn't a point taken that these calculations, without penny feathers, there'd be a shortfall. So all I'd say in my client's defence is not why it's not before you, is because that was before the judge below. It didn't seem necessary to address the points on appeal. If the court would be prepared to see that witness statement, because it was before the trial judge, I would like permission to put it in, if it is to be my client's to be criticised for not putting it before
No,
this.
it's not criticism. You want us to do something, say there's no substantial prejudice.
Yes.
All I've got is the witness statement of Miss Wilkinson, and I expressed yesterday the difficulties I was having in understanding it. And I've got a disembodied piece of paper, which is an email from February. So that's where we're at. It's not a criticism. That's the evidence you put before this court.
But I think you're asking for permission to file it.
Yes.
If it's going to be important to the outcome of this appeal.
Yes.
Yeah. Now, what do you say about that?
Don't object to that.
You don't object?
No.
All right. Well,
So-
we'll give you that permission.
I'm grateful. my lord.
When will we get to see it?
I can produce it by, I can't do it now, but could I do it? I eventually not going to deliver an extemporary judgment, so I could do it by the end of the day.
My clerk will bring it over, my lord.
If that's acceptable, then I'm grateful to Mr. Streeton for arranging that. Thank you. So, I think I can only take it as far as this at the moment, which is to say my submission is there is not a £70,000 shortfall without Westacre. That was my error. It's not in material. This document was before the trial judge and exhibited to a witness statement by Mr. Long. And that was before him, and the court will see that. And my submission on the back of that is that there wasn't therefore a shortfall, there wasn't therefore material prejudice, and therefore if it had been uploaded, the outcome would highly likely have been the same. And that's the submission I want to make. And my Lord Lord Justice Singh, this might be an appropriate point to address Gallicol, because my Lord put to me a question about how to approach section 31.2a. Is it simply the outcome, or is it whether the process leading up to it would have been the same? And I do say you do get some help from what Lord Justice Coulson said at paragraph 38.
Right.
It's a very short paragraph. Perhaps I can just invite the court to
Yeah.
remind itself of what he said in that.
Yes. Yeah. Well, that all seems to be fairly conventional.
Yes, is whether the same decision would have been reached.
Yeah. We're not going to shirk our obligation. Parliament has imposed the duty on the courts, which it has, but at the same time, I would remind you of what we said in the Friends of the Earth case,
Yes.
that there is still a constitutional division of powers between the judiciary and the executive. And it's Parliament's wish that it's the local planning authority which should make substantive decisions, not the courts. It may well be that we find ourselves in the situation where we cannot say, according to the statutory formulation, that it's highly likely, because we don't know what the outcome would be, and that's classically the function of the court, is to say that there's been an error of law without prejudging what the outcome would be.
Absolutely, my lord. And just to give you that reference, that's 273 in Plan B Earth.
Yes.
My learned friend quite properly invited me to draw your attention to that, as I would have done, but you've got there first. And it's 273. I don't demur for anything that's said there or suggest to persuade you otherwise.
No.
My simple point is that when you're performing that exercise, it is the outcome that you're looking at, not necessarily whether the process would have been the same. That's the simple point I want to draw.
The outcome would not be substantially different if the error complained of or if the conduct complained of had not occurred.
Exactly.
It's the impact of the error on the decision-making process.
Exactly right, my lord. Yes.
No, I accept all of that. And public law has never been interested in procedural points simply if they're barren technical points.
Yes.
But process also does matter because it may have a material impact on the outcome.
Of course.
And one has to be very careful, not even subconsciously, to trespass into the proper province of the executive.
No dispute with me at all on that principle,
Thank you
Lord. That's the simple point I wanted to make.
Right.
So I've taken the court to 284, and I'm grateful to the court for providing me with the opportunity to file that statement. The pleaded error here under ground 2 is a failure to have regard to an obviously material consideration. That is the focus of the point, and that is the ground of appeal. You have favour in the bundle at tab 17, page 354. I just want to remind the court shortly of what's said there about officers' reports and the scope of what goes into a report and whose decision that is.
Oh, yes.
So we're in favour, tab 17, page 354. And it's just between the letters C and D on that page.
Sorry, which page?
Sorry, 354, my lord, of the authority bundle.
Yes, I'm grateful. Yeah. Between
C and D, in the judgment of Mr. Justice Sullivan,
Yes.
it is the officer's expert function in reporting to committee how much information needs to be included in his or her report in order to avoid burdening a busy committee with excessive and unnecessary detail.
Yes.
So it's not the legal point that every single piece of information relevant to determining the application must be in a report. Part of the planning judgment of the officer is to decide what's the essential bits to put in. And my lord, in my submission, the fact that the penny feather scheme had lapsed was not obviously material for 2 reasons. Number 1, there was an alternative funding mechanism without penny feathers. And number 2, penny feathers remained an emerging allocation in the council's submitted plan. So in my submission, this wasn't a situation where the failure to expressly refer to that consideration vitiates the legality of the decision, because obviously I accept it was a relevant consideration, but it didn't go into the category of something that was so important that without it, the decision couldn't rationally stand. So that's my submission on the obviously material consideration element of ground 2, which is the element to which the trial judge directed his attention, primarily because that is the focus of the pleaded ground, and in my submission he was right for the reasons he gave. If I could just show the court that, you're in the core bundle. Paragraphs 83 and 86. Page 62 of the core bundle, if you're following there, if we've extracted the judgment, it's 83 to 86,
Yes.
where the judge identifies that even without penny feathers, there would not be any adverse effect. In any event, it did come forward, meaning that some mitigation and land acquisition may not be needed. The assessment concluded judgment 4 would operate with spare capacity. And then he says, I'm not satisfied that in these respects members were misled or took into account material considerations or acted irrationally. And in my submission, he was right for the reasons he gave. So, my lords, unless I can assist any further, those are my submissions on ground 2.
Right.
And that then ties up my submissions on ground 1, because if I'm right about that, I say I make good my 3rd proposition on ground 1, that it wouldn't highly likely have been substantially different if the conduct complained of had not occurred.
There's different conduct. The conduct complained of for ground 1 is the failure to publish the agreement.
Yes.
If you're right, and if it's page 284, they might have written in and said, what's RTS? Why is that relevant? Take that out. That's the conduct complaint of, the failure to publish, and give them the opportunity to comment. Round 2 is a different failure, that which occurred in the planning committee and what they were told by way of update, given that the penny feathers permission had lapsed 2 or 3 days earlier.
I accept that, my lord, but my submission, there is an interrelationship with them, because I say that if this document or the contents of 284, the 106 agreement, had been published, the outcome, i.e. the grant of planning permission, would highly likely have been the same.
Well, how can we tell? Because we don't know what they would have said, and we don't know what the council would have done. They might have said, yes, you're right, RTS should come out and they should pay an extra 70,000.
Because the only evidence before the court is what's said under ground 2 by way of complaint about highways mitigation. It's not said, there's no evidence before the court that now having had sight of the Section 106 agreement, that they'd have liked to have commented on something else. The focus of the deprivation is highways mitigation. So there is obviously, I submit, a relationship between ground 2 and ground 1, because it's not said there's any other aspect of the 106 they'd have wanted to give evidence.
You know, it is only highways,
Yeah.
but Mr. Jordan says, and he may be wrong, that where's the 776,000 coming from? And he'd want to argue about that. And that's different from penny feathers being told. Just so that you don't assume that if you win on 2, you win on 1. I'm simply pointing out there are different considerations.
And I accept the different considerations, my lord, not seeking to persuade you otherwise of that point. But I do say there is a relationship between it, because the test is highly likely, not inevitable, and that was a change that Parliament instituted. You have the material before you, you will have the witness statement that exhibits it. And in my submission, if you to roll that scenario forward, if they'd have written in and said, penny feathers doesn't exist anymore, so that contribution comes out, so 400,000 that's in the 106 is not enough. The council would have written back and said, as per this email, it is enough. And that would have been the end of it.
No, they were written back and saying, what is RTS? Why is that being included? Because we don't know anything about what the RTS is for. First time we heard of it was this morning.
Well, it has been in evidence throughout the proceedings, but it was not new to this court. It was below, and it was exhibited to a witness statement. There was no application to cross-examine that witness.
Anyway, we've just got to deal with the evidence we've got.
Yeah, and will have. And I'm grateful for the court allowing that in. So, my lords, those are my submissions on ground 2 and 1. I now turn to 3 and 4, which I can take more swiftly, subject to my lord's standing orders point, which I have looked into, and I do have an answer for them. So, ground 3 is the bias ground, or the appearance of bias ground. The principles I set out in my skeleton at 40 to 43, there's no dispute between the bar about what the appropriate principles are to apply. And the overarching submission that I make is that the function of an appeal court in this instance is to police whether the trial judge misapplied those principles or failed to identify the correct ones. And you have, in my submission at page 59 of the core bundle and at para 68 of the judgment, a correct encapsulation of the relevant legal principles. And in fact, when pressed, my learned friend accepted that paragraph 68 was not incorrect in identifying those principles. So in those circumstances, where you've had a trial judge who's looked at the material in the planning court, so a specialist division of the High Court, and they've applied the correct principles, in my submission, the appeal court should be very slow to interfere with that evaluative judgment, which was at para 72, that in his view, it didn't give rise to an appearance of bias. And my simple point is that he was right for those reasons. I have gone through each allegation in my skeleton argument at paragraph 44. Would the court want me to go through that? Although I'm conscious that with my learned friend, you said, well, I've seen what you've said and we'll apply Porter and McGill and see if we agree or not with your ultimate submission.
Yes, well,
but I'm not going to take it as read that you want me to do that.
Well, we have both sides very detailed written submissions. So it's a matter for you how you present your oral submissions.
Well, Lord, I'll just take it up then. So paragraph 44 in my skeleton.
Yes.
I have there responded to the 9 complaints as they were set out in the permission to appeal skeleton, so the referencing is slightly different, unfortunately.
Well, as I say, we've read all of this.
And I'm grateful for reading that. You have the witness evidence of Councillor Brodie.
Yes.
And in my submission, the Councillor Churchman point, which is effectively the high point of the oral submissions that were put to you about it. Councillor Churchman wasn't a member of the planning committee, and she wasn't in the relevant ward in which the permission.
Yes, but do you accept that Councillor Brodie said to her, "You can only attend the meeting if you're going to speak in favour"?
Well, I can only accept what he's put in his witness statement,
Yeah,
which
yeah.
can I just take the court to that to make sure I don't... and you've got that at 34 in the supplementary bundle.
Yes.
And at paragraph 30, at page 36, he's addressing this point.
Yes.
At para 7,
Yes.
he sets out the relevant bit of the Constitution. He then says at para 8, I did not invite Councillor Churchman to attend the planning committee.
Yes.
And then he says over the page, para 9, Councillor Churchman indicated to me that she would be speaking against the item and she failed to identify any material considerations which were not already put to the committee. Yes. On that basis, I declined to invite her to attend the planning committee.
Yes.
So I accept that, because that's what he says.
Yes.
And in my submission, that was within his discretion to do that. And there were lots of people speaking against the application. And it was a perfectly appropriate way of managing that committee to say, I'm going to ask you whether you're going to say something that's not already going to be put, because you're not on the committee and you're not a councillor for this ward. And the council's constitution envisages that, and that can't, in my submission, give rise to apparent bias. It's not dissimilar, if I may put it this way, to a planning inspector saying to a group of objectors, it would be very helpful if you could corral what you're going to say into 1 or 2 spokespeople so as to better manage this planning inquiry. And in my submission, this chairman of a committee is not doing anything different, because ultimately he has to balance a fair hearing against the time that takes. And if that councillor wasn't going to say anything different to the other people who were coming and objecting, then he was entitled to say, and in fact had the power under the Constitution to say, I'm not going to invite you to speak.
In his written statement, he says he's answering paragraph 98.3 of the claim form, and
Yes.
that says this. Councillor Brodie refused Councillor Churchman permission to speak at the meeting unless she spoke in favour of the application. That's page 235. So he's answering that allegation specifically. That's what he says he's doing. So he doesn't say that you'd only be allowed, he said to her that you'd only be allowed to speak if you speak in favour. He explains a lot of what his thinking was, but he doesn't specifically address were those words said by him. So do we assume that they were said by him, since he hasn't contradicted that?
Or do we assume that they were not said by him, and what he said was only what he acknowledges in his witness?
In my submission, the latter is much safer, because that's what he's actually written in his witness statement. And there was an application to cross-examine him, which we didn't resist, incidentally, but the trial judge didn't want that to happen. But
there's no challenge on this appeal
No.
to that decision, which would be a case management
It would be,
decision.
yeah. And there wasn't there.
So do you submit that the normal public law position should apply, which is that we proceed on the basis of the evidence of Councillor Brodie in his witness statement?
Yes, the positive evidence signed by a statement of truth filed in these proceedings. And he does not accept, he said, you can only speak if you speak in favour. He's saying, you've told me what you want to say, you're not identifying another material consideration that's not already going to be put, and on that basis I'm exercising my discretion.
I'm not commenting on this case at all. I want to stress that, especially for the benefit of members of the public. But as judges, we have sat through a lot of trials, both criminal and civil. And in my experience, at least, what often happens is that people have differing recollections of an oral conversation in good faith.
Absolutely.
They sincerely have different recollections, because that's the way the human mind works. You tend to remember things that may, well, there can be many influences on why you remember things. But it's not that anyone's trying to mislead anyone, but people place emphasis on different things. They understand things because of the context. So they may understand that what they're being told is you can only attend if you're going to speak in favour, whereas actually what's being said is you can only attend if you're going to be adding something. I've got plenty of people who are going to be saying things against.
Exactly.
I don't know.
No.
I have no idea what actually happened. But what you're saying is the safest factual foundation on which the court should proceed is what the signed witness statement
Yes.
says.
Yes. Absolutely.
Right. So I think we understand your submission on ground 3. I mean, as I say, I don't want to curtail anything. I didn't want to curtail anything that Mr. Streeton wanted to say, but we understand both sides' written cases very fully.
Can I perhaps just draw one point to the court's attention? So I've addressed the 9 points in my skeleton, but I do finish that in my skeleton argument by drawing the court's attention to the transcript on paragraph 45. And I've just extracted it in my skeleton for convenience, but you've got that at page 200 of the supplementary bundle if you want to see it in context, which I wouldn't deny that you should look at it in context when you're reading it. But when you're applying the bubbles and wine approach, which is, is there a real risk this person had a prejudice against one party or its case for reasons unconnected with the legal or factual merits? There's a real risk of that from all the factual circumstances. And in my submission, A, nothing in the 9 allegations gives rise to that, and B, you've got a positive inference here in the committee meeting of this chairman saying something which is inconsistent with a finding that he's apparently biased, because he's saying, I don't mind what you do, but I want you to have sustainable planning reasons to do it. And in my submission, well, what on earth's wrong with that? That's what we would expect planning committees and their chairmen to say. So in my submission, you've got a positive indication the other way. Now, my learned friend has drawn attention in writing, not necessarily so much orally, to the fact that, well, after the meeting, Councillor Brodie became exercised about the safety of that resolution because of allegations of the way in which it was conducted. And it said, oh, well, that's all after the event thinking and him trying to backtrack on a position. But this is in the meeting. So whatever you make of that ex post facto approach, this is him in that meeting, seeking to say exactly what his thinking is. And it's through that lens in which I suggest the court views this conduct. A, on its own, it's not inconsistent with an unbiased chair. And secondly, you've got positive indications that he was unbiased, but his focus of his concern was, as the trial judge found, to make sure the decision was a legally defensible, robust, appropriate decision. And in my submission, that does not give rise to an appearance of apparent bias.
Right.
So unless I can insist any further, those are my submissions on ground 3.
Yes.
And I have left myself enough time on ground 4 to address a very interesting point put to me by the court, which is about standing orders. So my primary submission under ground 4 is the judge was right for the reasons that he gave, which is to say that even if there was a procedural error, it would not have made a difference because Councillor Price attended, participated and voted in favour of this application at the subsequent meeting. So in my submission, that's the complete answer to this, and the trial judge was right to find it that way. We do say, however, that the trial judge was wrong to find there was a procedural failing because of the rule, to put it neutrally for a moment, the rule in the Constitution that if you want to participate, you have to visit, be on a site visit. And
so your paragraph 51 says the Constitution provision that you're referring to, this is paragraph 50 and 51, amounts to a standing order within the meaning of 106 and paragraph 42 of Schedule 12.
Yes, that's my submission, because the meaning of standing order beyond paragraph 42 of Schedule 12 of the Local Government Act, which says it's anything that regulates the business of the committee, is not further prescribed or defined. There's no procedure for adopting standing orders, for example. There's no process.
I don't know if we've got it. Does it give a power to make something called standing orders, and it says standing orders will be this?
Yes, can I show that to the court?
Yes,
you have it in Spitalfields because the court extracted it, which is at the penultimate, tab 22, I'm grateful. 32, thank you, I'm grateful. This is in the Supreme Court judgment, and you turn up printed bundle page 642. You've got paragraph 6 of the judgment of the Supreme Court.
So
Excuse me. Paragraph 6 on page 642.
Thank you.
That's the power.
So let me just read that.
Of course, my lord.
A local authority may make standing orders, right?
Yep.
So the question is the rule, in inverted commas, standing order?
Yes, my submission it is. First point is that just to introduce the rule properly, I gave you part 2 of the part 2 of the Constitution as it stood at the time. It hasn't changed materially, incidentally, but as it stood at the time, Section 1, the Constitution. Then it says the Constitution is divided into the following sections. And where my lord was drawing my attention is it says under Part 4, rules governing how the council operates.
Yeah.
And it says setting out detailed procedurals, brackets standing orders, covering how meetings operate, including full cabinet scrutiny and other committees. But if the court turns to the second page I gave you, which is within the same section, Part 2, Section 8, you'll see the penultimate paragraph, in addition to the procedure rules. Does the court have?
Again, it's so unhelpful. We've
sorry,
got
Lord.
paragraph 2 introduction, we've got 1, the Constitution, then I've got a heading 8.
That's in the same part, my lord, I apologise.
What do you mean the same part? Is it in part
2.
Part 2?
Part 2, Section 8.
So there's a bold paragraph, section 6 to 7. There's a bold 6 sections, 2 to 7 that we haven't got, and then you get this.
That's right.
Right, okay.
They don't
this
add
says-
anything material to us.
Right,
in my
that's all right, just so that I know what this is.
Yeah.
And this says what?
Penultimate paragraph, in addition to. Does the court have that? Shall comply with.
Yeah.
Part 3 and Part 5.
Right.
And thus the relevant rule here, site visits, I'll show the court this in a second, but just to explain it, is in both Part 3 and Part 5. So it's in the shall comply with part of the Constitution.
So, just taking the stages, is it or isn't it a standing order?
In my submission, yes.
Okay, right.
Is standing order defined anywhere?
No,
Right.
it's not. Not in this Constitution or in the Local Government Act, beyond the power. And the Supreme Court, Court of Appeal and High Court all proceeded on the basis that the rule at issue there, which is that you had to be in the previous meeting to participate in the next one, was a standing order for the purposes of paragraph 42 of Schedule 12. I can show the court that. And the rule at issue there was simply within its planning code. So unlike here, where it's both within Part 3, procedure rules, and in the planning code, it was just in the planning code there. Let me show the court that now, so you've got it.
In Spitalfields?
In Spitalfields. You're still in 32.
Yeah.
And it's page 644 of the authority bundle.
Yes.
Lord Sales extracts there the relevant part. It's the one right at the bottom that was in issue 11.4.
Yeah.
I started paragraph 13,
Yes.
which tells me that Part D of that Constitution includes detailed procedural rules for the committee which are part of the Council's standing orders.
Yes.
And then Section 5 of the procedure rules, as defined there. And then paragraph 15, is that Section 11 of the procedural rules?
Looks like it.
Yes, and then you have it again in para 17, my Lord, Planning Code.
Sorry, paragraph 70 of the
Sorry.
judgment.
Yeah, of the judgment, yes, my apologies. They've extracted the bit from the Planning Code.
I'm just completely lost now.
Sorry, my Lord.
I'm still on paragraph 15, section 11, which I've written in section 11 of the procedure rules.
Correct.
Where are you now?
17.
17, I have
17,
17.
sorry. Forgive me, I was going to 17.
Yeah, I'd gone to 70.
Right, 17. Planning Code of Conduct.
Yes.
Right. And
So
this is not statutory terminology, this is just what they've chosen to call it.
Correct.
Right. But you're saying that the Supreme Court treats this as a standing order.
Treated 11.4 on page 644 as a standing order. Yes.
Can you say that again, please?
Sorry, my lord. Treated paragraph 11.4 at the bottom of page 644.
Yeah, that's in something called procedure rules.
Yes.
Yes.
Yeah, what's the relevance of something called Planning Code of Conduct?
Thank you. That the court didn't accept that was a standing order, but in our case, it's in both. It's in both the procedure rules and the planning code. So,
Right. Can I go back to square one?
yeah,
Am I to understand that the structure is the following? The Act gives a power to make something which the Council calls standing orders.
Correct.
They must have made it as standing orders, and it must be something capable of being standing orders. That's the law. Spitalfield, they made what they called standing orders, procedure rules, which had the relevant part in it.
that's not correct, my lord. They didn't use the term standing orders. It said the procedure rules.
Yes.
And the court proceeded on the basis they were standing orders for the purposes of paragraph 42 of Schedule 12.
I'm just looking at 13. I mean, we'd have to see the Constitution for this. But anyway, well, you carry on your submissions. At the moment, I'm puzzling as to how this helps us here. But
You might get, sorry my lord, you might get more help from the Court of Appeal judgment, where it's set out at 6:30 in the authority bundle. Sorry, 50.
so I'm at 6:30.
Yeah, so I gave you the wrong reference, my lord. I apologise. So the main issue at appeal was introduced at page 621. So that's the issue that was before the court, whether
Yes.
that exclusion was lawful, rather than whether it was a standing order or not. And then you've got the council's constitution quoted from page 624 onwards.
So the thing at issue in that case, whether it was a procedural rule, a standing order, or a code of conduct, wasn't the question.
No.
The real question was whether or not it was lawful, whether you could ever make a thing which excluded a member, to which the answer was yes, you can.
Using that power, yes.
Right. So that's not going to help us with your submission that the rule that you're relying on, which I thought was the guidance to members, is a standing order.
No, my lord, sorry, the rule I rely on is in part 3. It's also in part 5. I don't rely on that. Can I show that? That might be where the confusion has arisen. So if I take the court to the supplementary bundle, page 214. That is within part 3 of the Constitution, responsibility for functions.
And we know that because...
Because 2 pages back, 211, that part is introduced.
Sorry.
Sorry, 211, my lord. Part 3, responsibility for functions.
Right, so this is responsibility for function. It doesn't immediately sound like a standing order. And it
But-
says all the decisions be made in accordance with the following principles. And they're quite broad principles, yeah.
But we
And
do
you
read
go
that,
on.
of course, my lord, just pausing there, we do read that with part 2, section 8, which I showed the court a moment ago, which says you must comply. Penultimate paragraph. and then turning through.
No, I haven't
Sorry,
found it yet.
Sorry, Lord.
Because we've got 8 pieces of paper, I'm not always on the right one. I'm now back on this page 8, or
Yes.
8. Where am I looking at that again? It says part 3, shall comply with Planning and Police Committee rules.
Yes.
Is that it?
Yes. In addition, part 3.
I do wonder whether I'm looking at the right thing, because what you've taken us to on page 211 is something called Part 3 responsibility for functions, and what I'm looking at on the piece of paper you handed in a little while ago is bottom paragraph A, Planning Licence and Appeals Committee rules, Part 3, Section 7.
Which you have, my lord, at 214, which is where I took
Right.
initially.
So that's Section 7, additional rules.
Yes.
Right.
And then if you look at the 1, 2, 3, 4th paragraph from the bottom,
Yeah.
you see it there. And that's the rule I'm relying on.
Hold on a
Sorry,
moment
how does
then.
it begin? Only those members.
Yes, only those members.
Yeah.
So, it's a rule and that, whatever it's called, you say has the effect of being a standing order.
Correct. That's my submission, yes.
Would I have got that from, have I missed this in the skeleton? Or?
Well, no, my lord, because it came from my lord.
Okay, rule is standing order. And who decides then? It says the committee must comply.
And I say that because, taking the language of para 42 of Schedule 12, it is a rule for the regulation of their proceedings and business.
Yes.
And you have to comply with it.
And when you say you,
Sorry, one
it's
as a member.
if the planning committee has got to comply with it.
Yes.
So why is the chairman exercising the power of the planning committee to decide that a member shouldn't attend?
Well, he's responsible for the running of that committee
Yeah.
and for its conduct, and it's appropriate for him to supervise and police rules of its procedure. That is within the compass of the responsibility of the chairman of a committee, in my submission. Just to complete the picture, my lord, there is the planning code, which you do also have in the bundle. That's in part 5 on page 259.
Sorry, there was guidance that was referred to as well. Should we not see that?
Yes, that's what I'm going to take, my lord. Sorry, that's 259. We're in part 5, code. You'll see a heading site inspections. Sorry, my lord.
Right, where's the first bit that this all comes under? Is this page 249?
Code, yes, it is.
So this is guidance for elected councillors, yeah?
Within part 5 of the Constitution. And then if
Yeah.
you turn to 259, there is then a subheading site inspections.
So this is guidance for elected councillors, and the site inspections
Second paragraph.
is a guidance, yes.
Yes.
So I'm not relying on that as the standing order. My case, the respondent's notice, is based on the rule that you have at 214. And in my submission, that is a standing order. And it follows that if I were to be correct about that, the council were entitled to exercise that rule to regulate substantive participation in a committee, because that is the ratio of the Supreme Court's judgment in Spitalfields. So if it does fall within those terms,
Right, I have it.
then that's the outcome.
Can you just break that down for a moment?
Of course.
If you don't mind. I dare say that general proposition of law would not be in dispute, especially now the Supreme Court has said it.
And my learned friend helpfully confirmed that.
Exactly, yeah. So, but
Uphill struggle for him.
But there are several parts potentially to this inquiry. One, what happened? As a matter of fact, there seems to be some issue about whether he missed only 20 minutes of it or an hour of it.
Yes.
On your submission, what factual foundation should we proceed on?
Well, the trial judge proceeded on the basis of either.
Right.
And in my submission, that's the way that this court should proceed, because that's the way the trial judge approached the evidence before him, having supervised the trial and received the evidence that he wanted. So I don't think I can invite the court to take a different approach to the evidence than the trial judge, because that's not this court's function.
Right.
But my submission is the same on either.
Right. And the submission is?
That because Councillor Price did not attend the whole of the site visit, he was not entitled to participate and vote on that relevant matter. And I get that from Part 3, Section 7 of the Constitution, which you have at page 214.
Would you say that as a matter of law, one doesn't have to go quite that far, although you may want to go that far? Is the correct legal approach to say that Councillor Brodie was reasonably entitled to reach that judgment?
Yes. If I'm right about the first proposition...
Because you see, somebody might have gone to the loo for a minute and,
yes.
not been present for the entirety of the site visit.
Oh, I see my Lord's point.
So is there some judgment which
yes.
is called for?
And so it would have to be a rational application
Yeah.
of that rule, and I say it was. And the Supreme Court in Spitalfields confirmed that you can, by the power at paragraph 42, Schedule 12 of the 1972 Act, regulate participation as long as that's rational. So I entirely take my Lord's point. If that was an irrational application of the standing order, if it is that properly so called, then that would not be lawful. But my submission is it was not irrational.
I'm still a bit troubled by why the chairman can do this.
Yes.
If it is said that a member is predetermined it, it's for the member to decide. If it's said that the member is biased because he's distantly related to the applicant for planning permission, it's for the member to decide. This talks about the committee deciding. Have you any authority? There are cases where people are excluded from meetings, for example, Francis and others. Have you any relevant authority on why it's the chairman who decides this rule? And in Spitalfields, was it the chairman or the committee? Two questions at once, I'm afraid.
Yeah. Answer one, no, don't have authority for that proposition.
No authority on who it is?
No, but my submission is it is the chairman, can be the chairman, because that is the person responsible for the conduct and running of the meeting, including...
It's the same with predetermination and bias.
Although I suppose my law was slightly different with that, in that obviously there's a function for the council's monitoring officer with predetermination and bias,
which gives advice.
Gives advice, yes.
But it's the individual member, and I assume the committee could resolve that somebody be removed, or the councillor could resolve. But I'm struggling with why the chairman can't decide that somebody who has said blatantly, I'm going to vote against this come hell or high water, the chairman can't do that. But if the chairman decides that he was too long in the loo, he can knock him off. That's my current problem. I'm surprised that this is coming up in this way at this stage, but where we are. But you've got no authority on what it means, what the powers of the chairman are, common law, and when you say the planning committee in the part that you showed us, that means, or the chairman of the planning committee for this purpose.
Yes, I would make that second submission, certainly.
Is there something in the Constitution which generally talks about the functions of the chair of a committee, or the chair of this committee? Because that's where, if there is such a provision, that's what one would expect, is the chair's general power to regulate. I mean, speaking for myself, I'm not surprised that you make the submission that you do, because it's a bit like the presiding judge has to conduct the procedure at a hearing. And there are many contexts in which there will be somebody who is chairing or presiding a meeting.
Yes.
So it sounds right instinctively, but one would expect there to be some kind of express provision in the Constitution to say, but perhaps there isn't.
No, I don't know the answer to that question at the moment. I can check that, and if the court, perhaps with cooperation of my learned friend, would be content to receive a one-page reference to where that is, if it's there. Can I leave it on that basis?
Yes.
But if it wasn't there, just to cover off this eventuality, in my submission, that is still within the ordinary powers of a chairman of a committee.
Yes.
Because what else are they doing beyond regulating the committee in accordance with what the council has said? That's its procedure and rules that you as members must follow.
Yes.
So my submission is that there wasn't a procedural error in this councillor being excluded from participation in the July 2021 meeting. But in a sense, the court doesn't need to address that because...
Was there some suggestion, remind me of the facts, was there any suggestion at the time of that meeting, and we're now talking about July 21, aren't we?
Yes.
Yeah. Was there any suggestion by anyone else on the committee that Price should not be excluded?
Not that I'm aware of, no, my lord.
Okay, so I think you would submit that there might be an issue of law which may arise in some other case.
Yes.
If there's some conflict.
Oh, yes.
But here, all the chair was doing was, on the face of it, you submit,
Applying the rule.
giving effect to a rule of the council itself. And what's wrong with the person who's in the chair doing that?
Yes. It would be, in my submission, quite extraordinary if the chair of a relevant regulatory committee were not allowed to supervise and police the procedure at that committee in accordance with the rules that all councillors have voted on and adopted. Because that is one of their core functions in chairing a committee.
But they don't normally exclude councillors. I mean, bias predetermination, they don't have the ability to say, I'm sorry, you can't sit on this. They give them specific powers, for example, in relation to people who are not on the committee.
Yes.
But they don't have, it's quite a big thing to say, that you can't sit.
Well,
and you can't say it on important things, but you can say it on this.
But if the constitution of the council is in those terms, then why can't the chair of the regulatory committee not enforce them?
Because it's not in those terms. The rules say committee, and the question is, does that include, either under the rules or under the Shackleton's law of meetings, the power of the chairman to act for the committee?
Yeah, in my submission it must do.
I mean, the rules seem to say the chair will decide whether or not members outside the area can speak, and the rules specifically address that. You haven't shown us any rule that says the chairman will police the obligation of the planning committee to not let people sit who haven't been on the site visit. But you're saying, at the moment, because you haven't got any constitutional rules, that it's a common law feature or a common law power, presumably, of the chairman of a meeting.
Yeah, it must be
Is that the source of his authority common law?
Well, I think you would say not strictly common law, because we're dealing with statute.
Creature of statute.
But you would say it's an implied power.
It would be an implied power,
yes.
to promote the purposes and policy of the constitution that's been adopted, which has an express rule about participation.
But we may not get here if we accept your first submission.
Well,
this is academic.
Yes.
This is quite an important
It is.
matter for committees generally, and we may feel unhappy about dealing it in the way it's been dealt with.
Yeah. Well, I can only apologise if I've not assisted the court further on that point that's been raised yesterday, but in my submission, it was a standing order, and what follows from that is that the council had the power to regulate participation, and that's the law, as the Supreme Court has declared it. Didn't just regulate procedural aspects, it could regulate and control active participation in the committee. And the Supreme Court heard all of the arguments about the constitutional implications of that. Elected people, right to participate, political imbalance that might flow, all of that was considered by the Supreme Court, and its answer is no. you can do that. And in my submission,
who
that was,
exercised the power in the Spitalfields case?
yeah. So
Was it the chairman or was it the committee?
let me just check that, my lord. So page 646 of the authority bundle, you have power 23 of the Supreme Court's judgment. And it does say there that at the outset of the meeting, on the 14th of September, the chair explained that only councillors who've been present at the meeting on the 27th could vote on the application.
Yes.
So it appears that it was indeed the chair who exercised that power.
Well, hang on, that says that he explained what happened next. Did somebody say, I'm not going, and he said, get thee gone, or did they all get up and go?
I believe they complied with that, and the challenge was brought not by them as disgruntled councillors, but by the objectors.
Objectors, right.
And you get that, sorry, just want to take that on trust, you get that from Para 2 of the Supreme Court's judgment. The objectors to an application brought the judicial review.
In a sense, if you're right, it doesn't matter, because if he shouldn't have been there, he shouldn't have been there, and whoever stopped him being there was helping the rulers. That's another way of putting it.
Yeah.
That's why I was suggesting that it might matter in some other case, or at least this issue might arise if there was a division of opinion on the case.
Yes.
But here, you say it's completely unsurprising that the chair of a committee meeting chairs it.
And there's no suggestion the Supreme Court critical of the conduct of that chair, nor indeed seemingly in the Court of Appeal judgment. I haven't read the High Court judgment for quite some time. I think it was 2022. But there was certainly no criticism of conduct. It was the application of that rule. So my submission is that I make good, I say, what's said in the respondent notice is that that was the legitimate exercise of a power, and the consequence of that power did indeed prevent.
Why did the judge say that there was a breach, a procedural irregularity? Can you just remind us of the judgment? Because you're saying that part of the judgment is wrong.
Yes, so para 65. He is taken to Spitalfields. Sorry, my lord, I'll just pause so you've got it in front of you. Page 59 of the core bundle, and paragraph 65 is his conclusion in the judgment when you get there.
Yes. Yes, I remember the phrase of procedural irregularity.
Yes.
And why did he say it was?
Well, he cites Spitalfield in the Court of Appeal then, where he says it's lawful for an authority to restrict voting. And then he says the court referred to where and observed that was on a different point. Permission has now been given to the Supreme Court. And then all he says is, well, in my case, the present case, very different to where. Councillor Brodie made the decision that Councillor Price should not attend, let alone not vote, rather than leaving it to Councillor Price's own decision with advice if appropriate. That amounted to procedural irregularity. So his reasoning, as I understand it, is, well, because this was a direction, if you like, from the chair, this wasn't a case like where it was advice from the monitoring officer about predetermination. Therefore, this was a procedural irregularity.
Right, so is it your submission that whatever the legal position may have been at the time of the High Court decision in our case, that very recently the Supreme Court has clarified the law, and that now applying the Supreme Court decision in Spitalfields,
yes,
there can be no doubt that the chair of the committee was entitled to perform this function?
Yes, I can do one better than that, my lord, because at para 41, the Supreme Court's judgment, they simply agree with the Court of Appeal. They say they were right for the reasons they gave. So there was no difference of... So the law as stated by the Court of Appeal that was before the trial judge has been expressly endorsed at para 41 by the Supreme Court. That's correct.
Well, fine. But then do we need to look at where, because the judge appears to be
Yep.
distinguishing Spitalfields Court of Appeal, square brackets, now endorsed by Supreme Court,
Yes.
close square brackets. So is the question then in law, was the judge right or wrong to say Spitalfields is distinguishable by reference to where?
Yes. That's certainly
I don't think we've been shown where.
let me show you that.
All right.
It's tab 9, authorities bundle.
Yes.
I'll just extract the correct part of the head note.
This is a first instance decision.
It is, yeah.
So in terms of the doctrine of precedent,
Yeah, it doesn't.
the judge and this court are bound by the decision of the Court of Appeal in Spitalfields,
They are,
and obviously by the Supreme Court.
yes.
We're certainly not bound by Mr. Justice Collins.
No.
Right.
I mean, it seems to be paragraph 38. It's back to the question I was asking. On predetermination, because it was predetermination here,
Yeah.
the judge appears to say it's for the individual member to decide, and the most that can happen is the chair and the monitoring officer can indicate.
Yes.
And there was a separate problem that the reason for him not sitting was to do with something else. And that's what I was trying to get at when I was asking, was it the chairman and so on? And the answer is we don't really know, because Spitalfields seems to be a case where the chair explained the rules and the members complied. But in a sense, if the rules say the members can't comply, can't attend, whoever points it out, it doesn't matter as long as he doesn't attend.
Yeah. And is there any authority for the proposition, which, as my lord says, is to be found in paragraph 38, other than Mr. Justice Collins? Because, in other words, is it established law that on the question of predetermination, it's a matter for the individual member to decide rather than someone else?
I don't think there is any other authority for that. There is another case that you do have in front of you called...
So just before we leave this,
Yeah.
is there anything else you want to show us in this?
No.
Because speaking for myself, and I don't want to set hairs running, I really don't want to set hairs running, because I think that the court should only ever decide questions which it has to. But I don't regard it as obviously correct that in the case of predetermination, it's up to the individual member to decide.
Yes.
On the face of it, I can't see why the chair shouldn't be able to say. I'm very concerned that you went to the Evening Post last week and said, over my dead body, will this planning permission be granted? I think that you're apparently biased. I'm afraid you can't take part.
And of course, a member receiving a direction of that kind, because that would be a direction, could either propose a point of order before the committee to say the exercise of your chairman's power is inappropriate and I want the committee to second that and vote it down, or perhaps slightly less realistically, seek an adjournment to bring a judicial review for a declaration of that decision. I say slightly less likely because I think that's not very likely to happen on most local authorities, but it would be a procedure that could be followed. I think the more likely one is where you simply put a motion forward and say that I be allowed to participate, notwithstanding the chairman's previous direction. Do I have a seconder? Yes, it would be debated, a vote, and then if that vote was carried, well then I suppose they could participate.
I think of it in a different way. The council will have decided the membership of the committee usually annually, and they'll have published a list of committees and a list of members. And if I'm on the committee, I can attend. And if the chairman said leave, I would look at him or her and say, why? Where's your authority? This seems to be... Did you raise any of these points with the judge below? Did you show him the Rule 7 that you've shown us?
Yes, I did.
You did?
Yes.
And it's just not referred to in the judgment then?
No.
Right.
Okay.
Anyway.
Thank you.
I think actually I didn't show him the planning code. I just showed him part 7.
Well, since you don't rely on the planning
No.
code, that's not surprising.
No, indeed, no. But,
All right.
you've got it.
Now,
anyway.
as I say, I don't want to set hairs running, and the time is limited,
Yep.
so you've got 20 minutes to finish.
Well, so my submission on that is that my respondent's notice point is made good, that he was wrong to say there was procedural irregularity, because there was a rule, it was a standing order, it was exercised properly by the chairman, there wasn't a notice of motion that it be overruled, nor was there any challenge to that at the time, and therefore it was wrong for the judge to find procedural irregularity. The fact it came from the chairman rather than the council himself deciding, in my submission, that nothing turns on that, and that if that was determinative in the judge's mind, then he was wrong on that.
Right.
So in my submission, ground 4 succeeds on that anterior basis, but if you're not with me on that or feel you don't need to decide it, even though it's obviously important to my client for other committees for it to know the scope of its standing orders and procedures, I can fall back on the judge's conclusions, which in my submission were entirely sound. As a councillor who attended, participated and voted in favour of the application, so it was either academic or highly likely to have been the same.
Yes.
So, my Lord, may I just turn my back for a moment, because I appreciate I've answered some factual questions and I may be told I've got those wrong, but I'll just turn my back and check.
Yes, yes, please.
Oh, I see. I'm sorry about that. Yes. So, my Lord, I'm glad I did turn my back, because there's two things that I've now got. One is, with the assistance of my learned friends, for which I'm grateful, the witness statement of David Long.
Yes.
May we hand those up as well?
Please. Please do.
Yeah.
Okay. Yeah. Thank you very much.
No, is there anything specific in this that you'd like us to?
So, point one, it was to his witness statement that was exhibited. So that's how that came before the court.
Yes.
No applications cross-examine him. Now refer to the following documents. Email title Westacre Exhibit 3. And then this the council calculated the figure of by.
Yeah, that's the figure of 406.
Their figure.
Yeah. But what does this tell us about things that are not in the 406 figure?
Because it then says by multiplying the resulting figure by the total number of homes, i.e. the figure of 406,539. So it was a per unit contribution. You've then got the email that he's exhibited as his exhibit 3, which shows you how that's broken down. And you can see from that that if you took out Westacre, you'd have the cost that he has said of 772,087 for the junction work.
Sorry, just remind me which page we're looking at then.
That's 284 of the supplementary bundle.
Dividing these potential costs minus a high-risk contribution already received from another site,
Yes.
namely Hope Road.
Yes, and you see that actually on 283, my lord, of the email. We've subtracted the amount already received from Hope Road.
I'm sorry, I'm being slow.
Sorry, my lord.
To those. All I'm seeing at the moment is an email which is exhibited to Mr. Long's witness statement, which we see at page 284,
Yes.
where there's a figure of 406,000 odd given.
Yes.
And I see in paragraph 7 of his witness statement that he explains how the council calculated that figure
Yes.
of 406,000 odd. But what I'm not seeing at the moment, but it's my fault, I'm sure, is where anyone is saying anything about the figure of RST, 68,000.
Well, beyond that, he exhibits this email, which is the basis of the calculation for their figure, and you can then see from that email how their figure fits in to the overall costs. And you know what those overall costs are because they are in the bundle, around 770,000, and it's also in his witness statement. So you can see, sorry, my lord.
I look at the third bullet point of paragraph 7, and it says dividing these potential costs between the developments coming forward in the area of the junctions and the site.
Yes.
I go to page 283, I see Nicholson Road and Penny Feathers in Westacre, and I know from other evidence that those are developments coming forward. So I assume that RST is also a development that they think is coming forward.
Yes.
And that's got 140 houses.
That contributes 5% of the
Of the total.
Yes.
And
what I deduce from that is that if you take out Penny Feathers, 584,355,
and you accept that RST is relevant,
well,
you'll be okay. If
yes.
you don't accept it's relevant, you won't be okay.
Well, it's the court below, and therefore in my submission this court has the material from David Long that showed how the calculation A was calculated and B how it fitted into the costs, and he exhibited that. So the court has what's at 284, and it can draw such inferences from that evidence as it thinks appropriate. And an inference I'm inviting the court to draw is that if you took out Penny Feathers, it is obvious on the material the court has that there would be sufficient contribution to pay for the junction works required. Because you know the cost of the junction works, that's in evidence, that's 770. It's in two places, in fact, in the officer's report and it's in this witness statement. And you know how much each development coming forward in the area was contributing. So the way I put it, my lord, is you have that evidence for what it says, and I am inviting the court to draw an inference from that evidence, because it is obvious on the figures. Because if you took out Penny Feathers, you were left with 770.
Yeah. And you say this is classically gather coal territory.
Well, two things. One, it goes to material prejudice, which is a different point.
I know.
On gather coal,
Yeah.
it would be highly likely to be the same.
Because another way of asking the question is, what would happen if this court quashes the grant of planning permission? What would happen next?
It would.
And you say it's obvious what would happen next.
Yes, it would. The 106 is now published, so it says what it says. The court should proceed on the basis, in my submission, that what would be said about it is what's said in Underground 2, because that's the only complaint levelled about the highways, about the 106. If that is academic or doesn't add up or highly likely to be the same, well then what purpose would quashing the decision achieve? Because it would go back, the points Underground 2 would be made, and the council would say what I've submitted to the court.
I just don't think it's ground two only, because we've been taken to Mr. Jordan's statement.
Yeah.
Some of it I can see you would say doesn't cover what the purpose of publication is, but one of the things is the 777,000. Now you would say, well, that's answered here, but what if they want to say, no, it's not enough to get it from RST or whoever the others are, you should get it from Westacre, or RST is actually not feeding into these developments.
Well, 2 points, I suppose. First of all, Councillor Jordan is an elected council of the authority.
Yeah.
He says he's speaking for the Highway Authority, but he isn't, in fact, an
Speaking
officer.
for himself.
Yeah, speaking effectively for himself. You have the Highway Authority's responses. They do raise concerns about third-party land. In my submission,
The third-party land wasn't what I was referring to.
But they don't raise a point about calculation of cost. So he as the, albeit the councillor responsible politically for the Highways Authority, can make that point, but that's not a point shared by or made by those highways officers. So if that point were made, if it quashed and went back and Councillor Jordan or someone else made that point, well, the answer would be, well, we've got a rationally sufficient evidence that's from the developers and we've costed it. And you're not presenting any other equivalent figures or reasons to doubt those costings. And neither did the planning committee when it had that material. It didn't say, well, 770 won't build you those two junctions. It had that material before it. So all that could be said, can't really quibble with the 770 because that ship sailed because the committee had that material.
We know it's 770 and we know that
Yeah.
it was to be the full cost of that.
Yeah.
And yesterday, we were at a stage where it wasn't full
No.
cost. Now we're today at a stage where if we include RST,
Yeah.
and if we accept that that is in fact something that contributes
Yeah.
towards this development, that the traffic from those houses
Yeah.
are going onto this junction,
Yes.
then it may be okay because you've got enough money to do the junction.
Precisely. And what would be said? They would come back and say, well, which is the point that's being pleaded, I should add. Penny feathers has lapsed. That was an obviously material consideration. You should have told the committee about this. And what would have been said? They'd said, we had a funding mechanism without penny feathers.
I think one needs to separate the planning committee point. Did they need to know about another development? Answer, you say no,
Yeah.
because it's another development and the funding for the highways is going to be done in the section 106. They don't need to trouble themselves about the funding.
Yeah.
But when you get to the next stage, when you broke the law and didn't publish the agreement, that's another thing, because it's at that stage
Yes.
that somebody would have said, hold on a moment, we're just not happy with the way this has been done. You can't include RTS, or you shouldn't include something else. And that's the point that you keep saying, oh no, the planning committee needn't have worried. It's people being able to, if you'd done what you should have done by law, they'd have written in and said, no, this doesn't work.
But there's no evidence about that at all. So there's no one's put a witness statement and said, had you published this, we would have made this point.
Well, Mr. Jordan does.
So say again, my lord.
Mr. Jordan does.
But he was saying that before the committee, and he's speaking, he says, on behalf of the Highway Authority, but he's a councillor. He's not an officer of the authority.
No, I understand that. I thought he's got all those attributes, but I thought he was giving evidence in a personal capacity as to the sorts of things that he said, some of which you would say would go outside it.
Yeah.
On anyway, I think we're going around in circles.
Yes, yeah, I think we are.
Well, you have my point.
Yeah,
Which is, if it's quashed, it goes back. They'll say, see page 284.
That's why I say this is classically section 31 to a gather coal.
Exactly.
That you know what the answer is going to be, or certainly is highly likely to be.
Yeah, because it is a notch down from simple.
No, I know that.
Yeah, I don't need to tell my lord that.
Yeah. No, I know that's what the law says, but actually your submission is obvious what the answer is going to be.
It will, yes, I say I'd make out, if I was in a simplex jurisdiction, I'd say it is necessary to be the same, because what other answer would they come up with? Because those are the figures, that's the basis of the calculation. You've got the witness evidence now that was before the trial judge that exhibits that says that was the basis of the calculation. The complaint is take out penny feathers, you're short. The answer is no, we're not.
Yeah.
Where's the
No, we understand.
missing link that says we'd have addressed it? The second point is, my lord, you asked me about, is there a point of the Constitution that deals with the chair and their powers and all the rest of it? There is. The screen's now locked, my apologies, but can you just unlock it? There is a point, I'll just give the court that, and perhaps with then the cooperation of a learned friend will agree that that's the relevant page and put that in if the court are happy to accept it. But let me just read it out whilst I'm on my feet.
Yes.
This is suspension, amendment and interpretation of procedure rules, section 20 of part 2. And it says, subject to receiving appropriate advice from the monitoring officer, the ruling of the chairman as to the construction or application of these rules or as to any proceedings of the meeting shall not be challenged at any meeting. So, in my submission, the Constitution does vest that power of interpretation and application in the chair.
Yeah. Would that possibly found a basis for making a distinction between things like predetermination, which are not to be found in the rules, but are found in the general law?
Yes.
And something which is found in the rules?
It would, because I think I fall back on what I mentioned earlier to my Lord Justice Lewis, that in predetermination bias cases, there is an additional function of the monitoring officer,
Yes,
a statutory function,
Yes.
to police that ambit
Yes.
of the general law.
Yes.
And in those circumstances, you might say, well, it's not really for the chair to have the overall say. It's for also the monitoring officer to perform their statutory function, which might suggest why it says subject to receiving advice from the monitoring officer,
Yes.
the ruling of the chairman, etc.
Right.
So that
Okay.
would provide a principal basis for distinguishing between
Yes.
application of the
Well, what I don't want is further submissions after this hearing concludes, which it will shortly conclude.
Yes.
But what I will give permission for is that document to be filed with us, provided that's agreed by Mr. Street.
Yeah. Thank you, my lord. We will have that conversation afterwards, and subject to Mr. Streeton's availability, we'll get it in today.
All right.
I'm reluctant to ask one factual question, but I'm trying my best to get from the evidence information. I'm at page 31 of the supplementary bundle, and the thing that is, as you gather, currently preoccupying me is how do we know that RTS, or whatever it's called, is something to do with this road development. And I'm looking at line 6 of paragraph 8, where Mr. Jordan talks about the housing resulting from neighbourhood planning applications, Pennyfeathers, Rosemary Vineyard and Nicholson Road. Do you happen to know whether Rosemary's Vineyard is RT whatever?
I do, and it is.
It is.
Right. What did the initial stand for?
It's the name of the developer.
It may not matter.
Sorry, my lord, that's wrong. It's the name of 3 combined sites which comprise that scheme.
Right.
Right.
So you would submit that on their own evidence, they're accepting that RTN is a housing development that feeds into this. The one thing they wouldn't be able to do is go behind their witness statement
No.
and say, oh no, RTN is not anything to
Exactly,
do with this.
yeah.
Right. Yeah. Gosh, it could have been so much simpler with evidence, couldn't it? Anyway.
Right. It's 11:58.
Can I assist any further in 2 minutes?
Yeah, I'm very grateful to you.
Thank you very much, my lord.
Now, Mr. Streeton, do you want to reply?
Yes, my lord, I do. And I would just like to take one point out of order and then make my reply, which relates to that final point picked up by my Lord Justice Lewis, because paragraph 8 there refers to, if we could just look at it, so it was page 31 of the supplemental bundle.
Yes.
Other critical junctions further afield, such as St John's Hill Light, St John's Station Junction, Great Preston Road, and I just emphasise Great Preston Road, St John's Hill Junction and Smallbrook Lane in its entirety will require funding, as the total amount of housing resulting from neighbouring pending planning applications, Pennyfeathers, Rosemary Vineyard and Nicholson Road. So just have that in mind. Then if we could look at the witness statement that was put in today
So, Mr. Long.
from Mr. Long.
Yep.
Just going to find that.
I apologise.
No, it's long since you've disappeared. No, here he is.
And if we could look in paragraph 7 at the second bullet point, the sum for Great Preston Road is 530,000. The sum for Westridge Cross is 770,000. And so the combined sum is that 1.3 million figure. And when one looks at what we have behind tab 19, namely the, so it's not tab 19,
Yes.
for the calculations. Sorry, tab 20, my lord. No, that's wrong again. It's the maths.
29.
What document are you looking
Tab,
for?
sorry, it's page. It's tab 29. It's page 282 and following. I do apologise.
Sorry, it's right. 29. This is the email.
This is the email, yes.
Yeah. The email exhibited Mr. Long's witness
Yes,
statement.
precisely.
Right, okay. Yep.
And we see that that 1.3 million figure is what is divided, and RST goes into that 1.3 million figure. Now that includes both the Westridge junction and the other junction which I identified at Great Preston Road. And my submission is that on this evidence, it would appear that RST is contributing to Great Preston Road, as we saw from paragraph 8.
Sorry, you'll have to take this
Sorry.
slowly. Where are you referring to? It's a 3-page email.
Yes, so
where do you say this point is demonstrated?
well, 283,
Yep.
we get the figure at the bottom with the total of all of the developments.
Yes.
And it's the combined sum that we had in Mr. Long's witness statement, paragraph 7, second bullet.
Is it 1.359770p?
Yes. It's,
Right. That's the total figure.
and so that is not just Westridge Cross, it's also Great Preston Road.
Yep.
And RST, as paragraph 8 of Mr. Jordan's witness statement that we looked at behind tab 7 on page 31.
Yes.
Is concerned with Great Preston Road.
Well, you say that, but how do I see that?
Other critical junctions further afield, such as St John's Hill Light, St John's Junction, Great Preston Road, and St John's Hill Junction and Smallbrook Lane in its entirety will require funding as the total amount of housing from neighbouring pending planning applications, Pennyfeathers, Rosemary Vineyard and Nicholson Road. So he's clearly tying those two together in my submission.
But Pennyfeathers and Nicholson Road, on any view, or do you accept that they would be?
They're both.
Yeah. But where do we see that Rosemary Vineyard is only Great Preston Road, not both?
We don't have a full explanation.
Right.
But my submission is you cannot assume that RST is all going to go towards Westridge Cross. That is not a proposition made good on the evidence before you. And I will come back to this, so it's foreshadowing what I want essentially to say. But my essential proposition is it is not appropriate for this court to attempt to perform a mathematical exercise which has not been evidenced, and to make assumptions like all of RST will be available for Westridge Cross in the absence of evidence, because that would be a judgment, essentially a technical judgment. And if the local authority wanted to make that point, it could have made it in its pleadings or in its evidence, and it never did.
My recollection, but I may be wrong, is that a long time ago the courts said that if a respondent is in judicial review proceedings is going to invite the court to decline to give relief, whether it's under simplex or nowadays the modified test in the 2015 Act, that requires evidence to be put in.
Yes, my lord, and the burden is on the defendant to put that evidence in. And
right.
We don't have it in the bundle, but the very recent summary of, well, the relatively recent summary of the law on section 31 in the Savard-Bien
It's the Cava-Bien case, but that in itself is a case that's been subject to quite a lot of...
Yes, and that's why it's...
And you shouldn't take, some people say, the 14 principles and look at them out of context.
No, all I was going to say is that the first proposition in that case is the burden is on the defendant.
There's no doubt that the burden is on them.
No, to be clear, I have not relied upon that case because I don't think it's necessarily helpful to have. a contentious summary of the principles.
It's a first instance.
It's a first instance judgment to a deputy judge. Yes.
A deputy judge.
Yes.
Deputy High Court judge, yes.
Right. Well, I think you were wise not to draw it to this court's attention.
I didn't. I only raised it because it is the first proposition in an oft-cited list.
Anyway, I don't think it would be a contentious proposition.
No.
A, the burden is on the respondent. B, they have to file evidence.
Precisely. And I will deal with this, but the context here. Sorry, my lord.
I'm still trying to understand your factual submissions. I'm looking at page 168 now. I thought there'd be something in the report that said 77,000 from the developer, but I'm probably wrong. I'm looking at 168.
Yes.
And all we're talking about is the financial contribution to two junctions at the top, the Westridge Cross and the Smallbrook Lane and Great Preston Road. I have seen somewhere, and I have fixed in my mind, that, and I thought, is it in the report?
It's the next report, 184.
184, okay. So, yes, there we are, I've marked it. So, for those two junctions, it's 777. And that's where I got those from. So just, what you're saying is that there might be 777 overall, but not all of that is going to be used for both those developments, because the RTN bit might be used for one development, but not for another development.
Yeah, yes, precisely.
So the RTS bit may not be making a contribution, or not a full contribution, to the 777.
Exactly that.
Yeah. Or at least we can't be sure.
We can't be sure of it. We haven't got the evidence.
Exactly. Yeah.
And it's not appropriate for this court to try and work backwards from the numbers in an email without the evidence. In circumstances in particular where the paucity of the evidence was very much a point raised by my client at first instance.
Well, okay.
Right, so what I've written down is that we cannot be sure on your submission that RTN will contribute to that part of the 777,000 that relates to Westridge Cross.
Yeah.
Right. Contribute in full is probably the clearest way for me to put it.
Yeah, and I don't think you necessarily need to say can't be sure, can't be confident.
Can't be confident. You can't be satisfied. It's highly likely.
What's the significance of the in full? I thought, it's my fault, I'm sure. I thought there were two junctions. Assume it's, I know it's 770, assume it's 400,000 each. And you've got 800,000 in the pot. I thought the problem was that no, you might have 400,000 in the pot if you look at RTN, but that's only going to be used for one junction. So you might be able to do that. But when you get to the first junction, the amount that is left from Westridge isn't enough on its own, and nobody else is coming in. So when you say in full, I'm struggling desperately to understand the fact.
My Lord's understanding is correct, and in addition, a secondary point is that there are other potential works referred to in paragraph 8 of Mr. Jordan's witness statement.
Yeah, don't go down rabbit holes. I don't understand this, Mr. Streeton. You're not going to get me to understand this by going on to other junctions. If you don't want me to understand it, then please do. But if you want me to understand this, I'm just trying to work it out. Say it's 800,000 each, and make the sums easier. It's going to be 200,000 from RTN, but it's only going to go to Small Lane.
Yes.
There's going to be 200,000 going from the developer for Small Lane, so that's 400,000 in total. There's 300,000 left, but that's not going to be enough, you're saying, for Westridge Cross. There's still going to be some sort of shortfall.
Yes.
Is that it?
That is a point and is enough. So that is a complete point and it is enough for me to succeed. A further point is that my Lord's understanding is premised upon all of that money from RTS, I apologise, going to a single place. But that may not, in fact, be true because it may need to mitigate itself in other ways.
There may be other junctions?
Well, the traffic lights that are referred to in that paragraph 8.
Okay.
And do we have to factor in Great Preston Road as well?
Yes.
Because
both.
It's both.
I know, but just for ease of analysis, can we just focus? All right. Is it also important to appreciate that although we're talking about the figure of 777,000, that actually on the papers you've shown us, the total figure when you include Great Preston Road is 1.3 million.
Yes, my lord.
And therefore, and I don't want to put words in your mouth, but I want to understand what the submission is. Is it part of your submission that RTS might be contributing to that additional 600,000? And so this court cannot be satisfied on the evidence before it that the RTS is definitely going to make good the 70,000 shortfall that we were noticing yesterday.
Yes, my lord.
No. Well, that's very clear. It may not be right, but it's certainly very clear.
And your simple point is, if they'd published and you'd written and asked, they could either have explained it or they would have rethought it.
Yes.
And they didn't do that, and if they wanted to explain it to this court, knowing that we're two very old, one very old, one very young judges trying desperately to follow it through, they should have put in evidence that made it simple.
Yes. And satisfied the court in accordance with the test and the burden that falls on them.
I hesitate to raise this, but where does the 1.3 million ever come from? I know physically where it comes from, but...
I was about to make a point
Yeah?
similar to that, or at least when I developed my submissions, which is that the position at supplemental bundle page 184, which we were looking at, that was the 777,
Yeah.
is to suggest that that is sufficient for both junctions. And to be clear, it says that that's on the basis of the applicant's own assessment. It's not adopted by the Highways Authority or anyone else at that point. It says this is a figure the applicant has given us.
This is both junctions in the sense that there are two junctions that are going to be affected by this proposed development.
Yes, so Westridge Cross and small...
Exactly.
Small, yes.
But not, for example, Great Preston Road.
Well, I think Small Lane and Great Preston Road are the same, so those are the two. But it's those two. And this is the point that the 1.3 million figure a year later in 2022 appears to be for the same or similar work. So it's not that you can just assume 777 is enough, because there appears to have been inflation from 2021 to 2022.
A lot of inflation.
Well, I mean...
It's almost doubled.
Yes, precisely.
This is all very odd.
And all of this just falls back into my point.
About 2 minutes ago, I thought I understood these figures. Now I don't.
No,
It may not matter.
But I think your submission, if you start at 168, the financial contribution has got to be towards the provision of highway works for the two junctions, Westridge Cross and Smallbrook Lane and Great Preston Road.
Yeah.
There is a figure in a later report, which is the applicant's estimate of 777,000.
Yes.
There is another figure, 1.3 million, which is higher, and that may be the figure that the council thought it actually needed for a financial contribution.
Yes.
If it's the higher figure, then we can't be sure they're going to get it. We can only be sure they'll get it if it is in fact 777, and if we add up all the different pots.
Yes.
That is the position, isn't it?
That is correct, my lord. Exactly correct. And so, in a sense, one doesn't need to go into the gymnastics, because 777 in my submission is not a figure made good on the evidence.
Well, it is a figure that's made good on the evidence. In this sense, it's their estimate.
It's their
You're
estimate.
saying that may not be the financial contribution necessary
It's
for
their
this development for the...
Yes.
Yeah.
It's their estimate in 2021.
Yeah.
It's not what the evidence doesn't make good is that it's a position accepted by the local planning authority or the highways authority as the appropriate sum 2 years later.
Yeah, because why are they looking at 1.39 million?
Precisely.
Yeah.
So, my lord, that was just me trying to deal with that before I came to the points that I proposed to make in reply, because I wanted to have that as clear as I could.
Yes.
And it maybe I made matters worse, not better.
No,
No, you have help there.
That's very helpful. Now,
so
in
I'm-
terms of time,
Yes.
12:15. When do you expect to finish?
May I say 12:45, and
Yes.
I hope to be quick.
All right, I will hold you to that.
My lord, I'd like to deal first with delay,
Yes.
and on the principles, I adopt, in essence, what was put to Dr. Bowes by my Lord Justice Singh in argument yesterday, and I would formulate the test as follows. Where an action by the local planning authority continues to play a material role in the decision-making process up to the date of granting permission, its lawfulness may be challenged within 6
Sorry,
weeks.
you're going too
I
fast.
do apologise.
I've got to up to the date of the.
Up to the date of granting permission,
Yes.
its lawfulness may be challenged
Yes.
within 6 weeks of that grant.
Right.
And my lord, I say that is the correct test for 3 reasons. Firstly, any other approach would undermine the public policy justification for the judgment in Burkitt, enunciated by Lord Stain at paragraphs 45 to 50. In that, it would introduce uncertainty and remove clarity. It would require judges to make just the sort of discretionary judgments Burkitt said are best avoided. And it would result in claimants feeling compelled to bring proceedings sooner than might otherwise be necessary, or which might never have been necessary, resulting in wasted expense to the parties and placing an additional burden on the court.
That's your first reason.
Yes. Secondly, it creates no insurmountable practical problem for local planning authorities. Because where a potential error in relation to a previous resolution is identified, whether that be through pre-action correspondence or otherwise, the local authority can revisit its decision with the benefit of advice from its monitoring officer, and if appropriate, exclude from consideration the previous resolution, which I say is precisely what Lord Stain envisaged in Burkitt at paragraph 39. And thirdly, my lord, my third reason is that the fact that the grant may be quashed in circumstances where, having received the advice from the monitoring officer, the local authority nevertheless proceeds materially to rely on its previous unlawful action, is unproblematic in public law terms, because it is no more than a manifestation of the rule of law, securing the certainty identified by Lord Steyne, i.e., there was a mistake, it perpetuated, the court corrected it following the final decision. Those are my submissions on principle on delay. On the facts, I say if that is the correct test, then the respondent's point on timing is bound to fail because the judge made a factual finding at paragraph 59 of his judgment below that the July 2021 resolution was considered by officers to be a material consideration in the grant, and that therefore the challenge was in time and properly included, to use his words, within
It goes slightly further than that. At paragraph 40, he said that the officers advised the committee
Yes.
that it was a material consideration.
Yes. Yes.
So it's not that they kept it secret to themselves.
No. Quite right, my lord. And it's paragraph 59 where he puts the two together. He says it was a material consideration and therefore the scope of the criticisms are properly within the compass of this claim. Well, those are my submissions on delay.
Thank you very much.
I turn to ground 1,
Yes.
where there is no dispute that Synergy provides the correct analytical framework and the application of that framework is the issue in dispute. My submissions, firstly, I deal with substantial compliance. And I say it is not tenable to submit that there was substantial compliance with Article 43b having regard to the statutory purposes underlying it. On the principle, I say that that purpose may fairly be characterised as to enable the public to view and comment upon terms of the 106 during negotiations, i.e. when it is proposed, and following negotiation, but prior to grant, i.e. when it is entered into. And in my submission, the public interest served by that statutory purpose includes the following 3 things. Firstly, that enabling comment is liable to result in better decision making by ensuring the decision maker receives all relevant information and that information is properly tested. Secondly, that it mitigates any sense of injustice felt by those who would have wished to object. And thirdly, that it reflects the democratic principle by enfranchising interested people to comment on measures capable of affecting them.
Sorry, what was your third point again?
That it reflects the democratic principle by enfranchising interested people in the context of measures capable of affecting them. Thank you. Well, those are my submissions on the principle. turn to deal with the facts. In my submission, failing to publish the section 106 at all in circumstances where the sum to be secured had never previously been published cannot constitute substantial compliance in light of those purposes. Because, my lord, it does not ensure the decision maker has all of the relevant information before them, let alone allow for that to be tested. Because it does not mitigate any sense of injustice. If anything, it increases it when people believed they would see something and couldn't. And because it does not reflect the democratic principle and enfranchise people, it ignores them.
Yep.
I turn then to deal with material prejudice. My submission is that there was material prejudice on the facts of this case. Before explaining why, I'd just like to identify what I believe are 2 points of common ground. The first, and I had understood that my learned friend was going to confirm this to the court, but I think he forgot.
I did forget. It's not in dispute.
Is that it is not in dispute that the evidence before the judge was that the appellant's shareholders were regularly checking the register. And the second is that whilst whether or not a request for the Section 106 agreement may be relevant to the degree of prejudice suffered, such a request is not a necessary condition for a finding of prejudice. And I say that must be right because a citizen is entitled to assume that the public authority will comply with its statutory duty and publish a document on the register. That, after all, is the purpose of maintaining a register. In those circumstances, my lords, I say that in this case the key issue is whether there were representations members of the public would have wished to make but were unable to make. And in my submission, there were. Firstly, there was the relevance of the penny feathers permission having expired. That is relevant to the sum and also the timing of receipt of that sum.
I don't understand the timing of receipt.
If the position taken by the local authority is, well, penny feathers will still come forward at some point,
Right.
then you may be waiting a very long time for the money to do the work.
I understand it.
Secondly, representations might well have been made as to the cost of procuring the highways works required to mitigate in principle, and that folds back into what I was saying earlier, that you cannot assume 770,000 was the figure for both sets of junctions, because in fact it appears the local authority's own position, different from the applicant's, was it was 1.3, and my clients might not have agreed with 1.3. As we see, what Councillor Jordan said is, well, if you've got to do a CPO, that's $500,000 in and of itself. Thirdly, my lords, a point which might well have been made is that you cannot make up the deficit later from penny feathers, as my learned friend suggested you could. So if you allow development to cause an impact, you cannot come back to penny feathers for that money later. And I say that because of the test in Regulation 122 of the Community Infrastructure Regulations, which is set out at Judgment paragraph 88. And all that really does is put into statute what was previously common law. But the test is not just necessity, it is also that the contribution is directly related to the development. And in my submission, it is at least foreseeable that a developer would refuse to enter into a Section 106 planning obligation, noting that their consent to it is necessary. It's not something that can be imposed unilaterally by the authority, on the grounds that making up the shortfall from previously consented development is not directly related to the development for which they seek permission. Finally, my lords, on ground one, I say it cannot be said to be highly likely that the outcome would not have been substantially different absent a breach of Article 43B. On principle, as I already said, firstly, the burden is on my learned friend. Secondly, as my Lord Justice Singh identified both today and in the Heathrow case at paragraph 273,
That was a judgment of the court.
I apologise, my Lord. In a judgment of the court, so it was the senior president of tribunals, my Lord Justice Singh, and I'm afraid I don't know.
Justice Haddon Cave.
And I think perhaps it is worth noting that the Goring case, which is what's cited in Gathercole,
Yes.
was a judgment of the senior president of tribunals along with the master of the rolls. It was a judgment of the court again, and Lord Justice.
Anyway, what's the point you're making?
The point I'm making, my lord, is that it does not fundamentally alter the relationship between the court and the public authority whose decision is subject to review.
Your simple point is, if we can't be sure about the figures for material prejudice, how could we be sure about the figures for no different outcome? It could be a different figure for the planning condition. You say they march hand in hand in this case.
I do say that, and what I would like to highlight in this context is two reasons for particular caution. The first, drawn again from paragraph 273 of Heathrow, is that we are in a planning merits and technical sphere where the court should be especially cautious of stepping into the shoes or trespassing upon the territory of the local authority.
This is a submission that one frequently hears on behalf of public authorities.
Yes, my lord.
And the courts give it great weight
They do.
when it's made by public authorities. And you I think, would say, well, the same applies when the boot is on the other foot.
I would indeed say exactly that. The level of caution should be no different. Secondly, because in this case, the court should be especially cautious of saying that representations would make no difference if taken into account in circumstances where the public authority must approach those representations with an open mind. And my lord, I say no authority is necessary for that proposition, but if it is necessary, it is to be found in the Law Society case, paragraph 141, for my lord's note, that is Authorities Bundle, tab 20, page 438, the judgment of Lord Justice Legges as he then was, and Mrs. Justice Carr as she then was. And thirdly, on the principles, I say that the fact that a decision is rational is not enough to satisfy the test under section 31, so you cannot elide grounds 2 and 1 in that way, precisely for the reason identified by my Lord Justice Singh, that on rationality there is a wide margin, and therefore when you are looking at whether it's likely to be the same, the margin applies in the opposite direction. On the facts, my simple point is that there is no evidence to make good the submission put to this court by my learned friend Dr. Bowes. Right. Mrs. Wilkinson's witness statement does not provide the answer. It identifies no numbers. It does not identify specifically which developments to contribute. And it includes no explanation of her approach to the lapse of the penny feathers consent. And my lords, the appellant's understanding is that this is all that the local authority had, because it did make applications for specific disclosure below, including for file notes, for your note. That was paragraph 14C in the supplemental bundle on page 13. And it raised the issues it would have wished to ask in cross-examination. I obviously accept that was refused. But the point that the claimant at that time wanted to understand this better, and the sort of questions they might have asked, was squarely before the defendant. So in a Huddleston context, when you're asking yourself, what should I explain to the court? Before you get to the duty of cooperation, the candour point is already on the table. You need to wheel out the good, the bad and the ugly. And so we can only assume this is what the authority had. I accept that's slightly artificial because of the second piece of evidence that we have, which comes from the developer, the witness statement of Mr. Long, and that wasn't disclosed, but plainly Mrs. Wilkinson was copied into it. So, query. But that does not get us where we need to go either. It does not explain what has caused the change in the costs from 777,000 to 1.3 million. And it does not explain how each of the contributions is intended to fit in, other than to the extent you can understand it from the email. So
can I just remind you that you've got 5 minutes?
I know I have 5 minutes, my lord, but this is where I wish to spend my time.
That's fine.
And my submission in light of that is that it all folds back into a single proposition, which is that this court cannot speculate. My lord, my final point in reply, or points in reply, relate to ground 5.
Ground 5?
Oh, sorry, ground 4. I do apologize. Ground 4. It's my 5th heading, it's ground 4. It's a delay.
Very good, yep, thank you.
Ground 4. Firstly, with reference to the pages put before the court by Dr. Bowes, I completely accept this is not a point that I have taken, but I do say that Part 4 of the Constitution in turn says that that is what contains the standing orders. Part 5 is codes and protocols, And part 3 appears to regulate procedure, but not as a standing order. Same way that the introduction presumably is not a standing order. Spitalfield.
It's not called a standing order. The question is, what is it in substance? Does it have 4 legs and a trunk and live in Africa? Chances are it's an elephant, whatever you call it.
Yes, my lord, and the same is true of the tenancy, I think. Yes. Ultimately, my submission is paragraph 17 of Spitalfield suggests there is a difference between what is said to be a standing order and what isn't, and on the true construction of part 4 such as it is, it appears that the standing orders are only those in part 4. I don't have anything more to say about that. My second point is that whether or not I'm right about that, my submission is that the judge was right to conclude that it was not for Councillor Brodie to exclude Councillor Price in the way that he did. And on that, I would just point out that he was not the chairman of the committee at all times. He was the vice chairman of the committee. Councillor Lilly was the elected chairman of the committee. And he was not in the chair at the time when he took the decision. And you'll see that from the supplementary bundle, tab 17, page 101. It's done the day before by email.
And just remind me, was it at the meeting on the 21st or 27th of July? Or is it the later meeting? Am I getting the meetings mixed up? There was one where they had a discussion about who was going to be chair.
Yes, that's the later meeting.
The later meeting. So when was it known, or how?
It was known. I don't mean to suggest otherwise. It was known that Councillor Brodie would chair that meeting.
Known when?
So I think, and I'm conscious of my time in looking in the bundle, but I think there's an exchange of emails very shortly before between Councillor Lilly and the monitoring officer.
But do you know if it was before the 26th of July?
Well before is the answer. It was known that Councillor Lilly would not chair the meeting well before. Because
so at the time that he sent the email on 101, it was known that he would be the chair of the
meeting? It was, yes.
Okay.
And I'm not suggesting to the contrary.
He was known and was the acting chair for the meeting, and that was known at the time.
Yes.
Yeah.
And then on where, which is what formed the basis of the submission below.
Yeah.
My Lord, it's Authorities Bundle, tab 9. My Lord, Lord Justice Singh asked whether there were other authorities on predetermination. There are, they're referred to in where. At paragraphs 38 to 42 there are 2. I think they're both first instance decisions. I confess that I have not had the opportunity to check whether there's appellate authority, because I didn't realise the point was in issue. But there certainly were 2 other first instance decisions to that effect. My submission is ultimately the question is one of construction on this council's constitution. Was it for the chair to exclude, or was it for the member? My submission is, absent something clearly to the contrary, it's for the member to determine, with the benefit of advice from the monitoring officer.
I have to say I find that surprising.
But the committee retains a residual power, my lord,
right.
And we see that from the witness statement of Councillor Brodie as it happens at paragraph 7 on page 36 of the supplementary bundle.
Yeah, let's give it a reference.
Paragraph 8 on page 38. Essentially, if a member persistently disregards the ruling of the chairman by behaving improperly or offensively or deliberately obstructs business, the chairman may move that the member not be heard further, and if seconded, the motion will be voted on without discussion.
So where are you reading from?
Sorry, it's paragraph 16, page 38.
Thank you very much.
Where he extracts from the council's constitution.
Yes.
The reason he does that is because of the exclusion of Councillor Adams, because we see an illustration of this later. He seeks to exclude Councillor Adams and doesn't succeed. So, absent something clearly to the contrary, I say it is for the member themselves to make the determination with the advice of the monitoring officer.
But that's member not to be heard further. It sounds as if they've made their point once and they just won't take no for an answer. It doesn't seem to cover this situation.
No, I wasn't suggesting it does. That's what I say is, if you don't have something clearly in the Constitution which says it's for the chair, then it should be taken
I
to
see,
the
okay.
member. And Dr. Bose and I will deal with that and identify any relevant passages of the Constitution immediately. My lords, those are my submissions.
That's very helpful. Thank you very much. May I check if there's anything else? Thank you all very much. Now, we're grateful to everyone concerned, not only the advocates from whom we've heard, for their submissions. We will reserve judgment. Drafts will be circulated in due course to counsel whose details were supplied before the hearing, so that they can draw our attention to any typographical or minor factual errors and agree a draft order so far as possible. And if they cannot, file written submissions so that an order can be finalised at the same time as hand down. Now, I must stress, in accordance with recent decisions of this court, that circulation to the parties or any other person for those limited purposes will be the responsibility of the recipients. Any such circulation is for those purposes only, and any other publication may be a contempt of court. And I stress again, for the benefit of everyone concerned, that this court will take breach of the confidential embargo very seriously if it does occur. Is there anything else before we rise?
My lord, can I just ask, that embargo allows the barristers to take instruction from solicitors and a relevant person, the client, because the trial judge restricted it only to counsel, which was quite difficult to then deal with consequential matters.
We are minded to restrict it to counsel, but we will, if that causes insuperable difficulties, then representation can be made in writing in due course, but that is our position.
We'll
All right.
My preference would be that it's counsel as well, but perhaps a way through is for my learned friend and I.
It's counsel only.
Counsel only.
Yes.
So counsel only, because I'm under direct access and I don't want.
You have a solicitor.
I don't have a solicitor precisely.
Exactly.
So my preference is that it should be counsel only. I think that the problem my learned friend is referring to relates to timing for permission to appeal, which was especially unfortunate at first instance because it was in the middle of the summer vacation.
Yes.
But we can deal with that by agreeing between ourselves extensions of time as necessary.
Well, there's a new procedure rule anyway dealing with time to appeal.
Yes. Yes.
I think
I'm,
it's 28
I'm
days.
sure we don't want to be unfair to anyone, and I'm sure that these things can be accommodated with good sense.
Yes.
All right. Thank you all very much.
thank you.
Right.